Good morning, everybody. Hello, welcome to today's webinar. It's the 23rd of September 2013 and my name is Amanda Chadwick and I'm a senior speaker at Peninsula Business Services Limited. Today we're going to talk about the use of zero-hour contracts and tell you everything really you need to know about the use of zero-hour contracts. But first of all, let me tell you, what is a zero-hour contract in the first place? The term 0 hours is not defined in legislation, but is generally understood to be an arrangement between an employer and a worker, which means the employer is not obliged to provide the worker with any minimum working hours, and the worker is not obliged to accept any of the hours offered. It is important that both the employer and the worker are aware of the fact that a zero-hour contracts can make their relationship different to other employment contract arrangements. This relationship should be established and secured at the start of the arrangement. There's been big stuff in the press which we're going to talk about in a moment, but some people are using these incorrectly. So, a true zero-hour contract worker is where the worker has no obligation to commit or honour any work offered, and an employer has no obligation to offer any work. So that's the true relationship here. Look, I'm not doing it actually. I'm not working those hours for you today. I know you've offered me them, but I'm not going to work them. No, I can't do Tuesday. No, I can't work Wednesday. I'm at college. I'm doing this. I'm doing that. And the employer doesn't have to offer any work to the worker. So we have had lots of recent press coverage. I have to say, from reading quite a bit of the press material that's in the papers, some people have got it wrong actually regarding the use of zero-hour contracts. But Vince Cable has brought spotlight onto the use of zero-hour contract. As a result, our advice lines have recently seen a surge in questions regarding the use of and also concern over employment status of these workers, which is a concern, and we'll talk about that later on. The Office of National Statistics estimated in the final quarter of 2012 that the number of employees on zero-hour contracts surged to over 200,000. However, information uncovered subsequently now suggests that this is a major underestimate, with the Chartered Institute of Personnel and Development, CIPD, going so far as to suggest that the true number has hit 1 million. The use of these contracts isn't new, everybody, but the surge in how many are being used is increasing, and this might have brought the spotlight onto them. And I think this is where the concern has come in. My concern is that employers may be using these in the wrong way. If used in the right way, for the right reasons, these contracts offer great flexibility to the right type of worker and a pool or banker staff to the right type of business or organisation. There's always been a grey area surrounding zero-hour contracts, I have to say. But as you know, I'm here and Peninsula here to help the employer. So I'm going to talk in employers' terms today. So, okay. Statistics show, we're going to go over this again, just a few of the stats, and then we're going to go on to the Working Time Directive, holidays, and things to remember regarding the zero-hour contracts. We know the statistics have grown. We know the number of zero-hour contracts and use has increased significantly over recent years. The total number of employees on zero-hour contracts has risen. We know that by 25% during 2012. News has emerged that it might be an estimate of over 1 million now. Originally, these contracts were commonly used in retail and hospitality to cope with seasonal surges in demand for services. It could be used in restaurants, but also the care service as well, and what we now know as domiciliary care. They are widely used, and especially where organisations and charities depend on funding. So what we're seeing now in service industries and also charities is more and more people using these type of contracts. They're now becoming more popular in other industries like education and medicine, which is beginning to buck the common notion that they're only used and useful in the lower echelon of unskilled workers. Zero-hour contracts are the contracts which offer the most flexibility to an employer. Using this type of contract means that an individual is contracted to work for an employer, but the employer is under no obligation to offer the individual a minimum number of hours of work per week. So there's no guarantee of hours for employee, and there's no guarantee of commitment or work for the employer. 0-hour contract is ideal for employers who have consistent peaks and troughs, and also in industries where they depend on, funding. When there is no work to offer, the employer does not have to worry about any layoffs or statutory guarantee pay, etc. On the other hand, individuals who are on a true 0-hour contract are not obliged to accept any work offered by the employer. Although the employer may build himself a pool of employees who he can call upon to come in and work, he is not guaranteed someone that can actually come in. So, this atypical method of working does not absolve employers completely from bearing some liability towards those on 0-hour contracts. Whilst true 0-hour workers will not be able to claim unfair dismissal, they still have a right to receive the national minimum wage and paid annual leave under the Working Time Regulations 1998. The administration of annual leave can be difficult for employers with 0-hour workers, and the traditional use of rolled-up holiday pay is theoretically unlawful following 2006 case law. Working out holiday pay for 0-hour contract holders is very complicated, and I do think it does require legal help. So let's talk about holiday entitlement to begin with. Just so you've got it right anyway, increases the statutory minimum holiday entitlement have happened, okay? So what we're seeing here on the slide is recent years and the changes that have occurred. So we've got before October 2007. So what I'm looking at is from the 1st of April 2009 onwards. What people should be entitled to is 5.6 working weeks. So to calculate an employee's holiday entitlement, multiply the number of days they've worked by 5.6, okay? So there's your example below. They're entitled to 28 days. But what we're looking at is 0-hour contracts here. And what I'm worried about is how you're calculating that at the moment. What I don't want to see, as I said, is the rolled up holidays, because that's illegal. So what I'm looking for is if you've got a worker who works casual or irregular hours, it may well be easiest to calculate the holiday entitlement that accrues as hours are worked. The holiday entitlement of 5.6 weeks is actually equivalent to 12.07% of the hours worked. And in case you're wondering how we work that out, the 12.07% figure, it's calculated like this. Now, I'm not a mathematician, so I didn't make this up, okay? But we have got this spot on, and this is right. So if we look at the 5.6 weeks holiday, and we divided that by 46.4 weeks, being 52 weeks, 5.6 weeks, and multiplied it by 100, that would work out 12.07. Are you really interested in the calculation of how we got that there? No, but I can assure you that 12.07 is the sum that you need to be working with. The 5.6 weeks have to be excluded from the calculation, as you would not be present during the 5.6 weeks in order to accrue the annual leave. So that's where that 52 weeks minus the 5.6 weeks comes into the equation, okay? So what we're going to look at here is, for example, if you'd worked 10 hours, you'd be entitled to 72.6 minutes paid holiday. And how we've come to that is we've put 12.07% times 10 hours equals 1.21 hours holiday, or 72.6 minutes. That makes it look simple, doesn't it? So let's not look into how we work that out or the pattern of how we work that out, because we can get very complicated. Just look at, if you're going to work it out hourly, you need the figure 12.07% times the hours worked. That will equal how many holidays they're entitled to. The holiday entitlement is just over 7 minutes for each hour worked. So, benefits of 0-hour contracts to the employee. Well, in a country where legislation has been a focus in recent years, for goodness sake, for giving employees more time off to be able to undertake other commitments, interests outside of work, flexible working, parental leave, right to time off for study, training, shared parental leave, 0-hour contracts fits in really well to an individual who wants the flexibility of the ability to earn money, but also to be able to pursue other activities. Whilst flexibility may be a good thing, the unpredictability of not knowing when the next period of work will be coming in might not suit everyone. It's great for an employer who wants an alternative to employment. A 0-hour contract also means that an individual can keep their hand in and maintain their skills. It's superb for students and ideal for a worker who has more than one job. So, things to remember though for the employer. This is absolutely crucial. This is the main part of it. Workforce status. The start of the relationship with a worker might be as a worker, but the lines can get blurred, okay? What happens is further down the line, the relationship gets stronger and it suddenly turns into what we now know as an employee. However, the way the relationship with that worker develops may enhance the employment status to that of an employee. Ways the relationship can change are continued hours, frequent hours, no bursts or short bursts in employment, disciplinary rules and introducing procedures. So actually taking your worker and treating them as an employee just by taking them down a disciplinary route or giving them an employment law handbook suddenly makes them an employee. This is where the relationship can change. This is where we talk about blurred lines. 0 hours status has to stand up on paper in the contract as well as in practice. So you might say, oh, they're on 0 hours, but if you start giving them regular hours and treating them as an employee, guess what? They're not a 0-hour worker. And this is where we get discrepancies. And you know what? Discrepancies and disputes will surely be judged at a tribunal. So let's get things right from the start. Let's issue a contract, but not a statement of main terms. We're not issuing a statement of main terms. We're issuing a contract that clearly states they are a worker and that it's 0 hours. We're not giving them an employment law handbook. We're not giving them the conditions of employment. We're giving them a worker handbook that has to be tailor-made, especially for a worker. We need to say at the very beginning, we are taking you on a 0-hour contract, because I know for sure in the UK, when they talk and they say that nearly 1 million people might be on 0-hour contracts, I know there'll be a large percentage of those employees that do not know that their statement of main terms, what they think is a statement of main terms, but we would consider it a contract for workers, is 0, and it says 0 hours. I wonder how many people have checked. Right, so we're not issuing a statement of main terms to a worker, we're issuing a contract with 0 hours on it. We're issuing a worker handbook, not an employee handbook. Do not put any wording of procedures or policies or use that phrase when dealing with a worker. Do not follow disciplinary procedures or grievance procedures. Make sure you're on top of the minimum wage. Make sure they're getting paid the minimum wage. And you need to consider there the implications of on-call, etc. there, or travelling to or from if they're in domiciliary care. Have proper calculation of holiday pay. I think I made it simple for you with a 12.07% per hour for you. So have a proper calculation of holiday pay and how you're going to pay them that and how they take it. Ensure communication of calculations. So make sure they know how you calculate the holiday pay so there's no queries later on. Make sure you have a casual relationship. So let's have breaks in the relationship and make sure they're always aware that they don't have the obligation to accept the work that you offer them. Do not impose penalties if the worker you feel lets you down. If they refuse hours, that is their right to refuse hours. Okay, like it's your right not to offer them hours. So don't impose penalties and say, well, if you don't take these hours today, I'm not giving you any work next week, because that is penalties. Do not do that. Keep a check on how frequently you use them, because the relationship can suddenly change, and vary the workers that you're using so that you make sure that this is truly a 0-hour contract. Things to remember: if Vince Cable is shining the spotlight on 0-hour contracts, it's time for you to review them. It's time for you to look at the use and why you're using them, and to make sure that you've got the correct use in place, that they are genuine, 0-hour workers, that you have a working time, you're looking at the working time, that you're not issuing state and domain terms, and that you are varying all the employment that you have with them. So look at the working time issues, as I said, and make sure that they are entitled and that you know they're entitled to holiday. And when employment is continuous, certain employment rights accumulate over time. So you need to make sure that if the employment is continuous, that you are keeping up to date with employment rights. And this is where it doesn't become a 0-hour contract. The relationship changes. So when employment is broken, an employer has certain responsibilities too. This includes a need to pay the worker for any accrued and untaken holiday pay. It is important for employers to actively monitor their need for 0-hour contracts. It is more effective in certain circumstances to use agency workers or recruit staff on fixed-term contracts, or it may turn out that the need is permanent and therefore a permanent member of staff can be recruited. So it's always best to keep on top of this, isn't it? In my opinion, that's what the best thing is to do anyway. Always monitor what your workforce status is of your employees and your workers anyway, because suddenly, as I keep saying, they accrue rights. So, rights of workers, this is what you need to know. Paid annual leave during employment, irrespective of number of hours worked. However, the amount of leave permitted will be dependent upon length of assignment and hours worked per week. Payment of any used on holidays, given out and paid out upon the engagement ending. The right to certain weekly and daily rest breaks. The right to statutory sick pay dependent upon certain requirements being met. The right to be protected against deductions from wages and or the non-payment of wages. The right to be protected against discrimination on the grounds of race, sex, disability, age, part-time status, sexual orientation, religion or belief. The right to receive the national minimum wage, and there are certain thresholds, remember, dependent on the age of the person. No less favourable treatment for part-time workers, and they are covered under health and safety. So I like to see an induction for health and safety training, and then them to say that they understand it, and sign to say they've read everything. So just a quick breakdown of the working time regulations. In general, the working time regulations provide rights to a limit of an average of 48 hours a week on the hours a worker can be required to work, though individuals may choose to work longer by opting out. 5.6 weeks paid leave a year, 11 consecutive hours rest in any 24-hour period, a 20-minute rest break if the working day is longer than 6 hours, and 1 day off each week. A limit on the normal working hours of night workers to an average of 8 hours in any 24-hour period, and an entitlement for night workers to receive regular health assessments. There are special regulations for young workers, which restrict their working hours to 8 hours per day and 40 hours per week. The rest break is 30 minutes if their work lasts more than 4.5 hours. They are also entitled to 2 days off each week. Any proposals to change of patterns of working are best carried out in a consultative way. This is for employees, by the way, explaining the reasons behind such a move and the benefits which may accrue to both the organisation and worker. That's for the bottom bit is for employees. So remember, records of the weekly hours worked by all workers have to be kept for at least 2 years. These records must be available for inspection by a relevant officer of the Health and Safety Executive or local authority who are responsible for enforcing this legislation, and the employer must cooperate in providing these records. The working week, what is calculated, and this is for 0-hour contractors, remember this. The working week is calculated with your normal weekly working hours and any job-related training. Job-related travelling time, including where this is an integral part of their work, business working lunches, time spent working abroad for a UK company, paid and some unpaid overtime, time spent on call at the workplace. This is really crucial because you can have people on 0-hour contracts waiting around for work. So this includes time sleeping when you're either working or asleep while on call at the workplace where sleeping is allowed. Time spent on call elsewhere while you are actually working. So I think the top tips for you here regarding 0-hour contracts is to make this relationship as casual as possible, to ensure that you have a contract in place that clearly states they're on a 0-hour contract, to make sure that you're not treating them as an employee, so you're not issuing a statement of main terms or an employment law handbook. You're just giving them a worker handbook with some conditions in there, which might include, for example, a search policy. You're making sure that you don't go through any disciplinary routes or procedures or mention when you're talking to them about policies or procedures, and making sure that you treat them just as they are a worker on a 0-hour contract. It's up to you, the employer, to manage this. So you need to make sure that you're always in touch with what their workforce status is. And just remember that it can change. So make sure that you're on top of how many hours they work, the breaks that they're having in employment. What you also want to make sure is that you are paying them the right holidays. And remember the calculation of 12.07% and the calculation. I hope I've helped you today. It's really not a very long webinar today because there really isn't a lot to say about 0-hour contracts. I do think it is time to look at what contracts you've got in place because there is spotlights on this. So if Vince Cable is showing spotlights and there's lots of evidence in the press and people are talking about the use of and the incorrect use of 0-hour contracts, I do think there are employers out there that might be manipulating their staff and using them for the wrong reasons. I hope that you are using them for the right reasons because they are a brilliant tool if used in the right way. I'm sure they will be around for a long, long time, but there will be penalties for using them incorrectly. If any of you are listening to me today and you are a Peninsula client, this is what you're paying us for. We need to check, if you want us to check the workforce status of the individuals, or you want us to write 0-hour contracts, or you want us to write the worker handbook, that's what you're paying us for. You need to use us as often as possible, okay? So make sure you're using the device line to help you with any of these aspects of employment law, because you're indemnified for the advice that we give you there. If you are not a Peninsula client and you'd like help and wondering what your workforce status is, you'd like to know how to write a 0-hour contract or really to look at all implications of workers or employment, you can contact me, and that's me. It does come through to Amanda at free@peninsula-uk.com. If you'd like any advice or you'd like us to know more about Peninsula or any a free consultation from us, contact me at free@peninsula-uk.com. If you're listening to me today and you'd like me to do a webinar for your clients, write some editorial for free for your magazines or publications or intranet or for the internet, you can contact me at amanda@peninsula-uk.com. Those services are available for free. If you would like to know more about our face-to-face seminars that we do, or our pension seminars that we're doing, they're free to attend. Again, contact me at amanda@peninsula-uk.com. This presentation today regarding 0-hour contracts and also the recording will be made available to you later on this afternoon on www.youtube.com/PBS Press Office. I hope you've enjoyed today's webinar on 0-hour contracts, and if there's any questions that you'd like regarding 0-hour contracts that I haven't covered or you think I've left out, again, feel free to contact me at free@peninsula-uk.com. Again, Peninsula clients, please use the advice line. Thank you very much for listening to me today, and goodbye.